One of the very first things that President Trump did upon assuming the office once again was to sign an executive order ending all DEI programs within the federal government. This directly undid something that Joe Biden put in place on his first day in office. You see, all the way back on January 20th of 2021, one of Joe Biden's first actions was to sign Executive Order 13985 titled, quote, Advancing Racial Equity and Support for Underserved Communities Through the Federal Government. This innocuous enough sounding directive ordered the entirety of the executive branch of the U.S. government to set up DEI goals and DEI initiatives. What this meant in practice is that every agency throughout the federal government, they had to submit something known as an equity action plan. These equity action plans, they detailed how that particular agency was going to further DEI objectives, usually by setting up quotas, DEI offices, hiring DEI quote-unquote experts, and so on. And so you had government agencies ranging the gamut from transportation to airline safety to the military to nuclear waste management. They all set up these DEI practices. And of course, this was actually mirroring what was already happening across the entirety of corporate America. And after 4 years of such policies, both in corporate America as well as in the government, the end result was exactly what you'd expect. An example of what the end result looked like was this report here, showing that corporate America overwhelmingly hired people of color. In 2021, out of the 300,000 new jobs that were added in Fortune 100 companies, 94% went to people of color. Likewise, you had this other report right here, which came out of the Bureau of Labor Statistics, showing that by 2023, American-born workers had lost more than 1.3 million jobs, while foreign-born workers gained 1.2 million jobs during that very same period of time. And so all this was great unless you happen to be a white, straight, American-born male. For many jobs, these policies really tilted the scales against you. And while the proponents of these policies say that this was a necessity in order to, as they say, right historical wrongs, the fact of the matter is that these were discriminatory policies that explicitly gave preferential treatment to some people over others based on immutable characteristics such as gender, race, and/or sexual orientation. Even if you agreed with the goals of these programs, the fact that they were illegal under the civil rights framework of American law was kind of undeniable. And actually, whether or not President Trump rolled these programs back using that executive order, well, they were already getting successfully challenged one after another in the court of law. As just one example of what I mean by that, let's take the case of San Francisco. Roughly 3 weeks ago, the city of San Francisco, they decided to settle a long-standing lawsuit. And in so doing, they're going to be ending their taxpayer-funded transgender guaranteed income program. And I do want to just quickly repeat that for added emphasis. San Francisco, the city, had a taxpayer-funded transgender guaranteed income program. This program of theirs, it was started back in the year 2022, and its stated purpose, at least according to the mayor's own website, was to, quote, provide low-income transgender San Franciscans with $1,200 each month, up to 18 months, to help address financial insecurity within trans communities. And so basically, if you happen to be a transgender person living in San Francisco, and if your take-home income was less than 30% of the median income in the area, you would qualify for a $1,200 monthly prepaid debit card, and you could get that card refilled for upwards of a year and a half. The program, it was announced in November of 2022, and the funds, they began to get dispersed 3 months later in January of 2023, which is great. But I'm sure that as you're hearing about this program, if it's your very first time hearing about it, you very likely have a simple question, which is, what would stop someone from just declaring themselves to be transgender in order to claim the money? They wouldn't have to change anything physically. They would just have to check a checkbox on a form and make the claim that they're trans. And so right away, there's a logical problem, a problem of proving that you actually qualify. Furthermore, if already the whole thing sounds discriminatory, it actually got a bit more discriminatory. You see, an organization called Judicial Watch, which is a, you can say, conservative legal watchdog group based out of DC, they filed a Freedom of Information Act request against the city government of San Francisco in order to get their internal communications regarding this program. And once those documents actually came to light, it was revealed that there was a racial component to this program as well. Up on your screen is one of the documents that came out of the city government from this Freedom of Information Act request. It doesn't have a date, but the title of this particular document is Mayor's Office of Housing and Community Development Prepaid Card Policies and Procedures. And here's specifically what these procedures state, quote, selected participants in this program will identify as transgender and extremely low income. Within this population, there will be a specific focus on Black and Latinx transgender women, meaning that even if you're a San Franciscan transgender, if you happen to be a white male, well, you still would be ranked lower. There was another document that came out which not only reiterated this race-based priority system, but also went even further by setting up actual quotas based on gender and race. This document here, titled Guaranteed Income Program for Transgender People, it also came out of this tranche of documents, and it said the following in part, quote, the program will prioritize enrollment and retention of BIPOC, meaning Black, Indigenous people of color, trans and non-binary people who also engage in survival sex trades, living with disabilities, elders, living with HIV and AIDS, undocumented, monolingual Spanish speakers, formerly incarcerated, and unhoused and marginally housed. The program enrollment will ensure the 55 participants are 66% BIPOC, at least 30% Black trans women, and at least 20% Latinx trans women. Again, what this meant in practice is that even if you were transgender, if you also happen to be a young white man, you would be significantly deprioritized to get into this government program. And if all this sounds like out and out illegal discrimination, well, you wouldn't be alone in thinking that. In fact, a group of San Francisco taxpayers thought exactly that, and they filed a lawsuit against the city government of San Francisco. Specifically, in January of last year, January 2024, Judicial Watch filed a lawsuit on behalf of the San Francisco taxpayers against the San Francisco mayor, against the city treasurer, as well as the director of San Francisco's Office of Transgender Initiatives. Their legal argument was that the Guaranteed Income Program for Trans People, otherwise known as the GIFT program, had preference-based qualification criteria that violated the Equal Protection Clause of the California Constitution. Now, the Equal Protection Clause in the California State Constitution, it pretty much mirrors the same clause in the federal Constitution. Here is specifically what it says in the state constitution. Quote, the state of California shall not discriminate against or grant preferential treatment to any individual or group on the basis of race, sex, color, ethnicity, or national origin in the operation of public employment, public education, or public contracting. And then it's really worth mentioning that later in that same subsection, it has another point which reads as follows, quote, for the purpose of this section, state shall include, but not necessarily be limited to, the state itself, any city, county, or any other political subdivision or governmental instrumentality of or within the state. Meaning that as a practical matter, the city government of San Francisco was definitely covered by the limitations set out in this clause. And indeed, roughly a year after the case was filed, the city of San Francisco, they capitulated and decided to settle. The settlement agreement was made public. You can see it up on your screen for yourself. And basically what the government agreed to were the following three terms. Firstly, they agreed to cover the taxpayers' attorney's fees and related costs, which amounted to roughly $3,250. Secondly, the city will discontinue their guaranteed income program. And then lastly, the San Francisco city government, they agreed to not create any new programs of this type, meaning that after this settlement, they can't just go and create a new program with a new name, but that still had the very same eligibility criteria. Basically, the program is dead. Now, while probably the recipients of these gift cards are not thrilled with this result, the president of Judicial Watch, he released a statement saying that he's pleased with the results and that this is a win for the rule of law. Quote, this settlement is a huge victory for taxpayers who oppose taxpayer-funded woke racism and transgender extremism. This settlement agreement puts a stop to the illegal use of taxpayer money to hand out free cash to transgender individuals based on race and sex in blatant violation of California's Constitution. And I really want to reiterate here that this victory was not just a standalone. This was part of a growing trend. Anti-discrimination lawsuits of these types against DEI programs were proving successful one after the next. I mean, even just for Judicial Watch themselves, this was not the first lawsuit of this type that they won just in the state of California alone. Back in 2022, Judicial Watch, they likewise won 2 court battles against California's so-called gender quota for corporate board laws. They had 2 laws on the books. The first was called SB 826, and it required all publicly held corporations that were headquartered in California that they must meet a quota of female board members or face fines. But actually, to be more specific, because this was California after all, the law, it specifically required that every publicly held corporation that's headquartered in California had to have at least one director who, quote, self-identifies her gender as a woman on its board of directors. And it also stipulated that if the board was larger, they might actually be required to have up to 3 self-identified women on the board in order to avoid the fine. Then the second law, it was called AB 979, and it required those same corporations to meet an additional quota for board members based on race and sexual orientation. Meaning, essentially, that if you had a company that was headquartered in California and you were doing your job interview processes, you actually had to take into consideration the applicant's race, gender, and sexual orientation. And again, if this sounds patently illegal, well, that's DEI in a nutshell. Judicial Watch, they sued the state of California on behalf of several California residents, and in both of those 2 cases, they won, with the courts striking down both laws as being unconstitutional. And so the point that I'm really trying to get across here was that DEI, it had its moment, but it was always discriminatory by its very nature. And even though it took a bit of time for all these different lawsuits to make their way through the system, now that it's been 4+ years, the lawsuits are bearing fruit. Local governments are now being forced to stop these discriminatory practices, while at the same time, corporations are also being forced to stop these practices and dish out significant payments to the people who they discriminated against. And so all this brings us right back to President Trump. And it shows us that his executive order to end federal DEI programs was not an anomaly. It was actually part of a growing national trend. However, and this part is quite interesting, the individuals in these federal agencies are not just taking these developments lying down. For instance, some agencies, they are reportedly just renaming their DEI departments to different innocuous sounding names in order to try and float under the radar. Others are getting even more creative. For instance, up until January 21st, Miss Lisa Boykin was listed as the Chief Diversity Officer within the ATF. However, on January 22nd, her position was changed on the website to simply read Senior Executive. Another interesting example was made public by Senator Ted Cruz. He posted this redacted all-hands email, which included some interesting, you can say, federal rebranding. Here's what it said, quote, "As we move into 2025, we plan to change our office names. The Office of DEI will be known as the Office of Access, Culture, and Opportunity. DEI itself will be known as the Collaborative Opportunities for Research Engagement. The DEI lead will be known as the Access, Culture, and Opportunity lead," and so on and so forth. There's like 7 of these different name changes. Now, the only problem with this approach is that for the past 4+ years now, these DEI programs were done all completely out in the open, and so everything is within the public record. There really is no point in trying to obfuscate something that can simply be looked up either on federal payroll records or by simply looking at the Internet archives. And along that very line, the Trump administration, they sent out a notice to all federal offices warning them that any attempt to either hide or obfuscate their DEI programs will be met with adverse consequences. Here's part of what the memo said. And again, this is the memo that was sent out to every single agency within the federal government. Quote, "We are aware of efforts by some in the government to disguise these programs by using coded or imprecise language. If you are aware of a change in any contract description or personnel position description since November 5, 2024, to obscure the connection between the contract and DEIA or similar ideologies, please report all facts and circumstances. There will be no adverse consequences for timely reporting this information. However, failure to report this information within 10 days will result in adverse consequences. And they leave it up to your imagination to guess what those consequences might be. And so there you have it. If you'd like to read more regarding these different lawsuits against DEI and the executive orders, I'll throw all my research notes down into the description box below if you're the type of person that likes to dig into the weeds. And also, I should mention, I'm working on a new mini-series to publish over on Epoch Times. And I mentioned it in our previous episode as well, but the first installment of this mini-series, it will be about Operation Northwoods. Based on declassified documents that came out of the CIA, in the 1960s, the U.S. military had a serious plan to commit acts of terrorism against American citizens, meaning to kill American citizens, to blame it on Cuba, and in so doing, justify starting a kinetic war. The documents, they revealed that the Joint Chiefs of Staff were in on it, and the only thing that stopped it from happening was the fact that JFK would not go along with the plan and killed it. And so, because Trump is about to release the remainder of the JFK assassination files, I think this is a perfect first episode to do in anticipation of what is about to be revealed in those docs and those videos and those audio recordings that might be coming out. And then until next time, I'm your host, Roman from the Epoch Times. Stay informed, and most importantly, stay free.